Hello and welcome to the latest edition of the Education Magazine. There is a slightly different setup today as I am acting as your host. I'm Christopher McFarland, one of the solicitors here at Sinclair's Law. And joining me remotely is our usual host, Mr. Michael Charles. Mike, hello.
Hi, Chris. How are you?
I'm very well, thank you. So today's episode is going to concern the SEND review. Now, I think a lot of you in the SEND sector will have heard a lot about this over the last year. And Mike, we've had a lot of requests to do an episode on this review, haven't we?
Oh, absolutely, Chris. I mean, there's a lot of people who say there's a lot of things that are wrong with the current system, you see.
Absolutely right, absolutely right. So for those of you who haven't had the privilege of reading the 106-page green paper, Mike, could you give us a quick summary of what the SEND review is about and what its findings are so far?
Well, Chris, thanks. Yeah, I mean, primarily, the government has been concerned for a long time that outcomes for children and young people with special needs or in alternative provision is consistently poor. And there's been a lot of concern that's raised by parents that navigating the SEND system itself, and particularly in regard to alternative provision, is not a positive experience for children or their families. And furthermore, they say that despite the government's unprecedented investment in the system, I know a lot of people might say, well, actually, I've never seen it. They say it's not delivering a sufficient value for money. And so the government, in its wisdom, has decided that there has been a vicious cycle of late intervention and low confidence and inefficient resource allocation, which has been the driving force for a lot of these challenges. And as a result, they've proposed that there needs to be some substantial changes. And they cite in the beginning of their consultation documents that a number of statistics. They say that there's 15.8% of all school pupils, there's 1.4 million in England alone, have been identified as having special educational needs. And 12% of those pupils are identified as requiring special needs support. But what I find is extraordinary, Chris, is that 41% of teachers in 2009 reported that they have not received that they had received appropriate training, which actually the government say it's in terms of 41% say that they have appropriate training, whereas, of course, in reality, that means 59% have not received appropriate training to support youngsters with very complex special educational needs. So this is a real problem that the government's identified, and the parents, involved and families involved in this have been very worried about it for a long time. And it's been one of the driving forces that's caused this SEND review, and I think no doubt it's been caused by the pandemic, because I think, as I've said in previous podcasts, that I think that the pandemic has enabled people to have a greater insight into their children, and what they can and can't do, Chris.
Yeah, I agree, Mike. I think the pandemic has proved to be a pinch point for a variety of things, but particularly we saw firsthand, really, how it was affecting those pupils with SEND and the challenges they had with home learning or accessing hub learning. And as you say, I think it has caused a lot of people to reflect in a variety of sectors, not least SEND. So, Mike, you talk about those issues there, and I think you and I, as practitioners in this area, do know that those are some of the key issues facing the system. So I suppose, what's not to like?
Well, what's not to like in the present situation, or what's not to like in the proposals? Well, I suspect the answer to the proposals is to first look at what those proposals actually are. And what the government is saying is that there needs to be a new national SEND and alternative provision system setting nationally consistent standards. And they also say that the SEN Code of Practice needs to be updated to reflect the new national standards, which they say is to promote nationally consistent systems. And also to establish SEND partnerships, bringing together education, health and care together to produce local inclusion plans. and introduce a standardized and digitized EHCP process, which, to be honest, from my perspective, I thought was pretty much standardized now anyway, although I know that councils tend to vary somewhat when they draft these plans. But also to support, they say, parents and carers to express an informed preference for a suitable placement by providing a tailored list of settings and to streamline the redress process. And they're talking about mandatory mediation. The one point that, Chris, you might, or those who are watching this podcast, might reflect back on what I was saying back in June when I issued a post on my Facebook about what I felt was concerning me there. So, Chris, what's your thoughts?
You know, Mike, I think it's really interesting, isn't it, that when you look at the SEND review, I think you have a situation where the government does identify a lot of areas of dissatisfaction. So a lack of assessment or late assessment or inadequate assessment are all issues that we come across on a day-to-day basis, you and I. And I think a lack of confidence and training in staff in identifying needs at an early level is, again, a crucial pinch point. And what happens then, which is part of what they've identified as this vicious cycle, is then that interventions come too late and then, of course, tend to need to be more intensive because you've already lost a lot of time, not assessing and not identifying needs. So in a way, in terms of highlighting some of the issues, I think it's done very well. But to me, I think that a lot of what the review doesn't say is almost as important as what it does say, because it does highlight, say, at paragraph 20, that of those who went to tribunal in 2020, there was a 96% success rate for the appellants, so for the parents and young people taking their cases to the tribunal. That has now continued through the 2021 statistics, the same 96% success rate. And what that shows is that actually, what we're seeing is that there is systemic non-compliance with the current system. And I think a lot of people have concerns that we're talking a lot about why the system doesn't work without really addressing that there is fundamental non-compliance with it. It's difficult to say that something doesn't work if nobody's following the rules. And that, I think, is one of the key problems that the review doesn't really make explicit. However, that being said, to increase compliance, there does need to be a review of the early intervention services. And there does need to be more support for children and young people. But I think everyone is very concerned that there's a lot of talk about the so-called adversarial system that shouldn't be in place for appeals, without fundamentally addressing that appellants and young people only go to appeals because they're not getting the support in the first instance. And what needs to happen is there needs to be much greater recognition on the part of local authorities that they're just not doing their job properly. And I'm not sure that at this stage of the review, whether it comes later remains to be seen, of course, that it's really making that point clear to local authorities that at the moment you are just not doing your job.
Totally agree with that, Chris. I mean, the irony is they tend to quote figures as though it's to suggest that the parents are embarking upon unreasonable appeals. And this is a dangerous misconception that this particular tremendous number of tribunal appeals is indicative of vexatious and over-litigious parents, which is absolutely not. I mean, it's actually indicative of, as you put it, a hugely deficient local authority approach to both assessment and to address the special education needs of children thereafter. How many people do we see who have been identified as having a complex array of difficulties with only one expert taking lead? And there's no proper evaluation of their motor sensory difficulties or their speech and language difficulties. And the local authority just guesses what that might be and suggests instead that there should be some form of approach taken by the teachers to try and help improve the child's sensory difficulties. So at the heart of this, I think, is there's a lot of deficiencies upstream in the assessment process, which I think needs to be addressed. And that's one of the fundamental things that I think that I would like to see reformed in this in the future. The need to be far more robust about the assessment at the first place and making sure you're involving the right people to evaluate and to address the right areas of need.
Absolutely right, Mike. And I think that, you and I obviously talked about this before filming this, and we've been talking about it for months, obviously, at the firm. And I think that one of the things, and we'll come on to, I suppose, the areas that we feel are more acutely concerning, but there are some, I think, positive high-level statements. But as ever, it's always about the execution, because the system, as we say, is really already there. You have best endeavours duties on mainstream schools to meet need under the Children and Families Act. You also have the Equality Act legislation requiring that reasonable adjustments are made for those pupils with disabilities. However, the reality is budgets are so overstretched at mainstream schools, and you and I always deal with mainstream school witnesses, or very often deal with them at tribunal. And, sometimes those experts and witnesses are candid, and they say, look, we just don't have it. I remember, sticks out in my mind to this day, about 5 years ago, going to an appeal, and a local authority was insisting that its mainstream school could meet this child's needs. And it was a simple thing of, was there a breakout area for this child to receive their therapy and other interventions? And, the expert witness for the school actually just laughed and said, no, we just don't have that. I wish we did. And it's so frustrating for parents that, these appeals, they don't happen suddenly. They happen realistically over a 6-month process, normally much longer. And then you get to the hearing. And, in that instance, the local authority insisting the mainstream school can meet need. But a very basic, pragmatic kind of assessment of whether it could do even the most basic things demonstrate that it couldn't. It wasn't that the school were hiding this. It was just they felt compelled to kind of go along with it. So the idea of, as you say, the identification of need is another issue, isn't it, Mike? Because you say we often see, even where there has been assessment, and there is a huge issue of when assessment points are triggered. And it's normally not until parents or the young person requests this, rather than school taking the lead. And I think, Mike, you and I both heard anecdotal evidence from local authority and school witnesses that say, well, we're actively discouraged from sending people to get assessed. Now, of course, whether that represents true practice or wider practice remains to be seen, but it's an often quoted anecdote I hear from schools that, they are told to try and deal with things in-house as much as possible, but without the benefit of a specialist assessment. But even if an assessment's conducted, we tend to find that an educational psychologist may only do an observational assessment rather than using standardized assessments to really get to the heart of where the child's cognitive abilities may be or where the specific area of needs are. But then even if the educational psychologist did an excellent assessment, and we do see those, it may have identified some language needs, social communication needs, or possibly motor skill difficulties, sensory difficulties, and then there's no follow-up from speech and language and occupational therapy. And I think the talk of having these multidisciplinary panels with more intervention from social and health sounds fantastic on the surface. But at the end of the day, if you're not actually going to be conducting proper assessments to measure these needs and to identify what support is necessary, I suppose the reforms are going to ring hollow. They're just going to be talking shops that aren't going to have the necessary information to make active and informed choices of how to support these children, be it through the education healthcare plan system or even with school intervention itself.
I totally agree. I mean, the other thing is, what is wrong with the current law? If you're following the current law, which obviously obliges local authorities to integrate into a package of support, the support that might be necessary from health, from social and from education, they're supposed to do that anyway, and they're supposed to cooperate together. What we are seeing, though, that there's no real deterrent against unlawful practices. And so when by the time the parents have taken the case to the tribunal, as well as I mean, there's lots of cases in which parents are saying, well, the council didn't do X, Y, or Z properly, didn't do that assessment properly, didn't use the right experts, didn't undertake the right tests, didn't seek advice from social services when it should have. And the tribunal say, well, look, we're not worried about the past, we're just going to deal with the present. And there's no sanction for that failure. And I think that's what's causing a lot of frustration among parents who are having to go through a tribunal process, go through that, pay the costs of going and succeeding. You're saying in the 90s that the success rate, and they've got no ability to recover those costs because the tribunal say, well, actually, we're looking forward. So there's a number of things wrong wrong. I mean, with the tribunal system too, I mean, there's no power to make interim injunction orders of the kind that a court could, dealing with a situation where a child, let's say, is out of school because they can't cope with the school experience. It's just too great, too anxiety provoking. And the evidence could be overwhelming that that child needs support outside of school rather than education within it. And the parents, have this argument that they want to take to the court to say, well, actually, you should be providing education otherwise than at school because my child's not fit enough. And the courts are saying, well, actually, you can go down the road of the tribunal and resolve your case down there because you shouldn't come to us. And yet the tribunal doesn't have the power to impose injunctive relief. And so it might take 6 or 7 months while the council prevaricate and delay getting the right evidence and the right support. And then 6 months down the line, the parent will then turn to the ombudsman, the local government ombudsman, and make a complaint. Well, actually, my child's been out of school for the last year because you haven't been complying properly. And the local government ombudsman criteria is to award a maximum of £200 to £700 per month of a child's lost education, which is just extraordinary when you think about it. So there's no real redress. And I think that's at the heart of it. In my opinion, as I said in my post back in June of this year, Chris, I said it's not a case of simply saying that the current law is fundamentally wrong. It's about strengthening it, making sure they comply with it properly, giving the tribunal more powers to force local authorities to comply. I mean, I think it's, there's a number of things really that does need reform. But I think at the heart of it, the councils need to reform themselves from right at the very start of the entire assessment process, because they're not doing that properly, it seems to me.
Absolutely right, Mike. And your comments there, I think, about education otherwise than at school are particularly prescient, and I think neatly lead us on to one of the key recommendations of the review, which is the greater integration of what's called alternative provision as part of early intervention and wider SEN support. So, Mike, for those who may not know, what is alternative provision?
Well, alternative provision in a general sense means something other than the conventional, something other than what you would normally typically have a child educated within. So, for example, a school, you may not, some children are not really that well engaged in schools, and they might need to go elsewhere. They might be home educated. They might be in need of specialist provision outside of school. And the government is saying that alternative provision is in this new reform, this new proposal, is to cover a broad range of different things, and it consists of a wide provider base. And so it might include pupil referral units, it might include alternative provision academies, and it might even include free schools and even independent schools and some unregistered providers, whereas we don't always get that easily entertained in an education healthcare plan when it's an alternative education provider. So there's a broader description of what the government considers will fall within this category. And so the government is saying that's going to be one of the key things that they're going to focus on is to promote this and see this more this alternative provision being included much more widely in the education and healthcare regime.
Yes, Mike. I mean, I think that's interesting, isn't it? As you say, alternative provision is something that you and I have come across, and maybe some of the people watching at home will have experienced, but it's not really used that commonly. And obviously there's a few overlaps, isn't there, within the SEN system of when alternative provision might be used. For example, if it's a particularly bespoke specialist provider, it might be used in conjunction with either a mainstream school or a different school. It could be used as a way to transition a child back into school if they have school anxiety or something of that ilk. Or, of course, if they've had other difficulties in school, possibly leading to behavioural meltdowns or other issues of that nature, sometimes you can have these providers help them better regulate and maybe help develop their skills to manage in the school environment before reintegration. But I think one of the issues that I personally have with the review itself is that although I think there is a lot of validity in the comment that there's a lack of joined up thinking with alternative provision, and there's a lot of or there's a lack of, I should say, intervention with alternative provision in a timely manner. I mean, the key example of this, Mike, that you and I have come across in countless cases, sadly, and I think, as we talked about before, these issues have only increased since the pandemic, is that of school anxiety. And, it's been a hugely disruptive couple of years with COVID. Children, young people have not been in education or have been in different forms of education, and of course have been told and required to be distanced from one another. And, there's an anxiety that has emerged, I think, alongside what we would typically see for school anxiety, which itself was already on the rise. And you did tend to find that what was usually happening was you'd get the education welfare officer involved, or fines would be issued to people who weren't attending, rather than having proper quality intervention from providers specialising in school anxiety to try and provide intervention. But I know that you and others have had a slight concern that the design or proposed design of intervention, that there may be, as it were, time-limited placements away from the school in these alternative providers, and targeted support from these providers for those with behavioural difficulties. And they say that behaviour that disrupts theirs or others' learning could lead to some other prejudicial practices. So, Mike, what could you expand on those thoughts for us?
Well, I've been long concerned. I mean, if you go back to the 1996 Education Act, I mean, the priority has always been to educate children in school. That's what the government objective has been. And then there's a small number of children who are said by the school or by their parents that they can't cope within school. And they've often been shipped into inappropriate settings. Now, that's not to say that represents all of them, but there's a fair number of children who have been lost in the system, and the government in its proposal is saying that a majority of children in state-funded alternative provision have been classed as children in need, and of those children, a whopping 41%, Chris, have been said, according to the government statistics, to have been cautioned or sentenced for an offence. So the historical concern that I had was that more often than not, children who historically have been placed into alternative provision have been placed in pupil referral units. And that's led them to become more and more disengaged from education. And they've been lost and left outside of good quality specialist provision. Now, that is not the same, I just add, to as home education, because home education can work very effectively, particularly when it's well resourced. So I think the concern that I have is that it was historically used as a vehicle for children to be off-rolled and then thereafter forgotten. And I can give you an example. I was asked not so long ago to assist a family whose child had a statement of special needs back in the day when statements were in existence. And he had not been in school since the age of 9. And at the age of 17, he had no education at all, right the way from the age of 9 to 17. And the parents were not at fault. They were banging at the door of the council to help because the child was just too complex. And he was actually supposed to have been registered to school all that time. So he was forgotten. And that case obviously is going to involve potential claims in negligence. But I think that the government is saying that there needs to be a better framework, a better system of coordinated practices to address the needs of those children who fall out of the system.
Yes, Mike. I mean, another example, I wholeheartedly agree with what you say, is, you talked about the behavioural aspects, and then going back to the anxiety aspect, one of the issues that we see, and I think there's considerable overlap here, as we've talked about, where with those who have special educational needs and those who may fall under Section 19 of the Education Act 1996, who are absent from school by reason of illness or otherwise. And I think it's important to distinguish those two as classes. It may be that there are some pupils who are not able to attend a particular school, or particularly a mainstream school, because it is unsuitable to their needs. And then there are those who are perhaps too unwell. And, with regard to anxiety and other forms of ill health, I quite recently, within the last 18 months, dealt with a case where a local authority's policy was only to excuse a child from school and engage in their Section 19 duties once the child had a consultant's view on their health, a consultant doctor's view. And the reality is, with NHS waiting lists, that's incredibly difficult to achieve, and certainly not in a timely fashion. And what we're seeing is that for the 6 to 8 to 9 months to however long it takes to get to a consultant, if you get there at all, these children are simply left outside of the system, as you described, and without adequate provision. So I think with this proposal, I think, as we talked about earlier, it's very much in the execution. It's not that these rights don't exist, and I think having a more unified system between alternative provision providers, maybe greater oversight and regulation of those providers as well, because again, we have more springing up now, post-pandemic, more tutors and things, which is both a positive in terms of it's great to have more availability, but potentially a negative if you were letting unregistered providers crop up who may not have good practices. Or may not have oversight and control from proper regulators. But equally, there is that risk, isn't there, that as you say with that individual who is put out of school at 9 years old and not returned to 17, there is the potential for exploitation where schools may be justifiably overwhelmed by a child's needs, not necessarily skilled or resourced enough to support that child's needs, and then perhaps use the alternative provision as a means to either discipline the child, moving them to an off-site provision in lieu of suspension and exclusion, which to some extent is a potential positive, but equally it can also prevent the child having the right to appeal those decisions, as would happen with a permanent exclusion, for example. And also, one of the key issues, and one of the key issues we talked about with this reform generally, is that does it really strike at the heart of the issue, which is recognizing and understanding a child's needs early enough, and also recognizing and understanding when the current school can't meet need. It's all well and good to say, well, we'll just flood it with provision and it will work. But you and I have seen that sometimes those piecemeal packages simply don't work, and there has to be an appetite to sit back and recognize where a child's in the wrong school environment, and rather than necessarily trying to plug the gaps with alternative provision, recognizing that no, this needs something more bespoke, more intensive, and actually a complete environmental change is required. So it's very difficult, isn't it, Mike, at this stage with proposals to give a full critique of every element, but because so much is in the detail and in the execution after the implementation has occurred.
Absolutely, Chris. I mean, it's difficult because even from the document in 106 pages, we don't really have a lot of detail about what is being proposed. They talk about national standards and they talk about good quality, calm, well-ordered provision. And then they also talk at the same vein in the idea that this should be short-term rather than long-term. So there's sort of snapshot moments where you have the right support in place for a child, and then the child then drop back into the same situation that the child was in a few weeks or months ago. So it's very, very difficult to come up with a clear enough idea about what the government is proposing at the moment. And I think the devil will be in the detail. What I'm concerned about, I suppose, is that the government will probably produce legislation that will give local authorities a cop-out, where in the present situation, you can claim that the child should be educated with, in accordance with the education healthcare plan, and this provision should be put into place, etc. And the government might say, well, there's a blanket alternative provider that you can go to, and this is on our approved list, and therefore all of the statutory duties are now being met through that, through the exercise of that service. So I think that I'm just a bit concerned whether this is going to result in a dilution of parental rights. It's difficult at the moment to say. The idea that alternative provision should be good quality, well-resourced, targeted, specific, addressing all aspects of the child's needs, of course, we should be applauding that. There are a number of children who simply are not well suited in school, and we have to recognise that. And I think if it's about grasping that idea and acknowledging that parents and children need a lot more help than that which could be delivered in the context of a very typical current alternative provider, then I think we should be encouraging this. But I think I'm concerned overall, as I said in my Facebook post, Chris, back in June, that the devil is going to be in the detail. And I think that when you look, for example, at the proposal, which is ultimately to compile an approved set of schools that local authorities will be able to suggest for parents and children, then I think in those circumstances I have real concerns, because that's going to be a fundamental dilution of rights.
Absolutely, Mike. So for those at home who may not have read the Green Paper, and we recommend you do, the links will be in the description of the video and on our website for those who wish to read further. The proposal is that at the stage where you would elect a parental preference for a school through an education healthcare plan, that your local authority will provide you with what they call a tailored list of suitable provision. And at the moment, that list is not provided in any kind of formal way. Some local authorities may have, through their local plan or through other resources, a list of available schools in their area, or may provide a list upon request, but it may not include necessarily independent providers or alternative provision in their area. Now, the idea, it seems to me, is that the local authority perhaps will, as part of its tailored selection, look to include those providers. Certainly the review paper seems to include that, but I think your and my concern is, Mike, is that rather than giving parents what they currently have now, which is, I suppose, an open opportunity to elect a preference, even if it's not something that the local authority itself might consider appropriate at that juncture, it seems to be guiding or possibly even limiting parents to that choice that is in the list. And of course, that, I suppose, tends to lead to more conflict rather than less, Mike.
Oh, I can tell you, an idea of an approved list is just not going to go down well, and it's not appropriate. It's a fundamental shift in the parental rights. It is a dilution of parental rights. It's unjustified, absolutely unjustified. I mean, in my experience, you cannot say that there is an ideal solution for every child. Okay, we have to be bespoke sometimes. So the idea that you can just have to look to one particular list and say, well, actually, you must choose from that is, I think, repugnant. Absolutely. I think it will fail a lot of children. And I just would strongly discourage the government from entertaining that as the idea moving forward. It's not positive at all. You should be improving parental rights. And the only demonstration of the reality is the very fact that so many parents go to the tribunals these days and win. And they are proven correct. So can you imagine if that scope was not open to the tribunal because, out of the list, there's only 5 or 6 schools that you could ever even envisage? We just simply can't go down that road.
Absolutely right, Mike. And I don't think anyone would oppose a list merely as a guidance document to say, here's what's available locally, have a look. But your right to express a preference is not impeded. It doesn't have to be from the list. We would recommend it's from the list. But, something along those lines of gentle guidance, yeah, absolutely. It can be very difficult for parents to find what's available in their area. And even online resources can be incomplete, and that's very difficult. Often parents are relying on Google search or local knowledge from other parents or carers in the area, which can be excellent resources, of course, but not as helpful as a comprehensive list. But I agree with you entirely, Mike. The situation changes remarkably where it becomes a mandatory list for selection and avoids the chance of things being selected beyond the list. That changes the dynamic entirely and would represent a significant dilution of rights.
Now, I think, though, Chris, you see, I think the very fact that they're bringing in this proposal makes me skeptical about all the other proposals that they make. Because you cannot, the idea that the government is going to put this into place at the end of this consultation exercise is, and to support what I consider to be a totally unjustified raid on parental rights, I think makes me, and it should make others, very concerned about what else is going to be in the detail that's going to come up and frighten us when this consultation period and when the whole exploratory exercise that the government are doing in relation to reforming education in this area what that's going to result in, I just don't know. I'm just very concerned about that, I got to say.
Absolutely, Mike. And another element in terms of resolving these disputes that has generated much controversy is this proposal that there be mandatory mediation. Now, Mike, I know that you are quite the fan of mediation, it's fair to say, and have achieved good results from it. So I will go to you first. What do you think of the proposal for mandatory mediation?
Well, firstly, I don't think that that mediation is not the panacea. It's not really a neutral advocate, to be honest with you, because what you'll find is that many mediation providers are, I'm finding, are not particularly that skilled in understanding the special needs area. I know they're supposed to be, but there's a lot of lessons that are learned when you are involved in mediation. And a lot of it is going to be spent on informing the mediator about what the law is and what the provision should be for a child in those circumstances. And we're seeing a lot of defects. For example, they're not bringing the right people to mediation often. You don't get always the decision maker there, and they should be there. You don't get health participating in mediation, even though they should be there. And social services, where are they? I mean, heavens. You don't often get a multi-agency response in the mediation, even though the law requires it. So I think it's a question of, at the moment, the idea that mediation should be mandatory. I'm not really opposed to mediation at all. I am, as you say, Chris. I'm generally in support of it if it's done properly. And I think at the moment, I think the headline point that I think you and I probably agree with is that what we have in the current law is not bad. It just is not being worked out properly. And I think if we talk about, multi-agency responses, alternative provision, we've got all that in the legislation at the moment. The local authorities are supposed to cooperate with each other. They're supposed to, at assessment stage, involve social services. They're supposed to involve health with a proper contribution. And we're supposed to have all of that. It's all enshrined in the Special Education Needs Disability Regulations. Yet what we're seeing at the end of the day is that local authorities cherry picking what assessments to do, local authorities then cherry picking who they should bring to the mediation, local authorities cherry picking what should be included in the education healthcare plan, and often dictating to the mediator about what they are prepared to discuss and agree. So I think if both parties are united in the spirit of trying to collaborate with one another and generally open and transparent about a child's needs, I think mediation is a good thing. But it's all down to the mindset of those who participate in it. So my broad view is that it's always better to try and resolve the conflict rather than go to a court or to a tribunal. I'm a big supporter of that. I don't think we as lawyers should be encouraging, battles at every stage. I think if a local authority comes to mediation and does so with good intention, there will be meaningful mediation, good meaningful mediation. We should be encouraging that.
I agree with that. I think for me, the concern that I have is making it mandatory. I think that, as you say, we currently have that voluntary system for mediation. It was one of the big changes of the Children and Families Act, and it has got its role and it can work well. I think the difficulty that I've found with mediation is very much some of the key issues that you mentioned. Non-decision makers turning up, which means that, again, it serves just as a talking shop, which often, as you and I will both know, Mike, and as many of the viewers will know, that's already happened. You've already had meetings. Parents have already had meetings with the local authority, repeated meetings. They don't come to us at the first stage, generally at the first stage. They come to us and they go to tribunal after multiple meetings have happened and a lot of talk happens, but very little follow through. Or a lot of platitudes are given to reassure that what the parents are very clear hasn't been working, is working, and they should just ignore their concerns. Oh, don't worry about it. That type of reassurance. And then, as you say, it's, mediation itself, I find that because it happens at an early stage, particularly if, as we going back to the point about assessments, where there's a lack of quality assessment, it can mean that the parties are almost talking at cross purposes. If you don't have an assessment saying, well, look, not only do we as parents know this, we now have an educational psychologist come in and done a completely independent assessment, the HCPC registered, they can only do what is within their professional judgment. and they're seeing similar issues. Maybe they've interpreted it differently, but they've got a totally different idea of this. And now we need to get this in the plan. I think that where you have that level of detail, I think mediation can be extremely effective and can often help narrow disputes between the parties. I think what frustrates me is because it happens at the beginning of proceedings, often those assessments aren't there, and then it seems to be that rehash of the discussions that parents and the local authority have already had and can sometimes talk in a circular motion. But it does have its place. And my concern is that whilst the quality of mediation can vary quite widely, as you say, between quality, helpful meetings where the parties really start to listen and understand each other's positions and hopefully can reach a unified position. You do have those circumstances that you know I've both discussed where it is just almost a waste of time. You're there for an hour talking about things and get no further. And my concern with mandatory mediation is you're going to increase that latter example of rubbish mediation rather than increasing quality mediation, because, as you say, it's already in the law. It is voluntary. So the local authority and the parents can say, look, we already know this case well. There's no need for us to go to mediation now. We've already spent our time talking about this. It's now time to move to the tribunal process. But of course, during the course of that, there is always ongoing negotiations. And I find that those are normally extremely helpful in settling matters. I mean, I would say the majority of my cases in particular don't make tribunal because once the evidence is gathered, once the parties are entering meaningful discussions with the benefit of evidence, it no longer becomes this, gulf between them, or very rarely becomes a huge gulf between them of opinions of, oh, we require an hour of therapy per week versus you don't require any therapy, what are you talking about? It may become more nuanced to, well, we think it's half hour per week versus an hour a week. And that's a much more narrow issue and a much more bespoke issue. But it does mean that the parties are coming closer. And often, we're going to tribunal, if at all, with a handful of things outstanding. And, the tribunal are often very complimentary of both parties where it's faced with that situation, because that's how it should be. It should be that only the minor issues, or, well, important issues, I say, but of the kind of quantity of issues, the very small amount that can't be resolved between the parties that get there. But I think with the mandatory mediation, you're going to force another hurdle between that ultimate destination of the parties with the benefit of evidence having that meaningful discussion, which often happens at tribunal or before tribunal, and kind of the starting point. It seems to be it's going to be another tick box exercise, which seems to, even from the review itself, increase costs, not make a meaningful difference to the dispute and cause, again, unnecessary delay. And that really concerns me, because when we saw the Children and Families Act 2014 come in, and again with the SEN reforms in Wales as well, one of the things that's been a repeated theme is that parents are generally satisfied with the outcome once they get there. Once they've had the intervention of the tribunal or specialist legal support, or even if they've just been with a local authority and managed to negotiate a document that they're happy with. There's high satisfaction rates at that point. The dissatisfaction comes with the months or years preceding that, where they felt like they're banging their head against a brick wall. And to my mind, I've got a horrible feeling that, unless the nature of mediation changes radically, or better yet, the quality of assessment proves radically, so we're no longer talking apples and oranges, we're at the very least talking two different varieties of apples when we get to these meetings, that again, it's just going to prove another hurdle to overcome for parents to ultimately beat a tribunal. So again, it's all about that execution. Mediation can work, but we have to understand why it's not working first, rather than simply asserting that it's not being given a fair crack. And I think that rings true to the wider appeal, Mike, and it'd be interesting to know your thoughts. It seems to me to be a great idea on paper. You look at the statistics, you look what the government thinks, and you think, oh yeah, at the macro level, this must be the right thing. But it seems to be almost blind to the real issues on the ground that are really driving these statistics. And that, to me, is a huge concern. It seems to be looking at things in a vacuum rather than as their experience on the ground and trying to fix those key issues that we've talked about, namely non-compliance and improper assessment and all of those issues.
Chris, I think at the heart of all of this, just before I move off the mediation point, I'll just make 2 points, really. The first is that mediation, you're quite right. I mean, in principle, it sounds great that if we can get people talking, it's the right thing to do, and it can narrow down the dispute that ultimately goes to a tribunal. But we're seeing in practice that they're only being assigned 2 hours as a norm to go through what could be a very complex case. And the 2 hours, the first half an hour is spent with the mediator talking about the procedure, etc. And you have an hour and a half left to resolve the details in the plan. I mean, I've seen local authorities turn up at mediation, for example, and saying, well, actually, we're not here to resolve the contents of the plan, which we're here just to discuss, routes to try and try and go forward rather than the plan. I mean, parents are just scratching their heads. I mean, that's the one point. So doing it properly is fundamentally important. But I think at the heart of all of this, Chris, I mean, the other thing I'm worried about is the delays that could apply as a result of this. I mean, for example, let's imagine you go to a plan that is to a dispute to mediation with over a plan that is not being properly put together because it hasn't used the right experts. Let's say at mediation you agree that the right expert should be used, and the mediation agreement is that in 2 weeks' time the local authority will commission a speech therapist or so. The speech therapist reports, the plan is updated, then we have to go to mediation again because there's a new plan. I don't know how often you might be going around. It might be Groundhog Day. When is that ever going to be? When is there going to be the decisive moment where you say, actually, well, enough's enough. We can't talk anymore. We got to go to the tribunal. So I think that needs to be really buttoned down. And we don't see that in detail in the green paper and in the proposals. But to be honest with you, Chris, if I had to think of my headline point that's wrong with the current system, right at the root of all of this is the assessment. I've said it right at the outset of this discussion, but I think grossly inadequate assessments should, in those circumstances, when a tribunal is confronting a situation where there has been a grossly inadequate assessment, there should be powers open to the tribunal to correct that, to require the local authority to return to it with an interim order saying you must do the assessment properly. And I'm in favour of the tribunal not being used as an opportunity for the local authority to vent its ridiculous suggestions and to disregard the statutory processes and just as a talking shop. I'm in favour of real sanctions being imposed against a council that defies the legal requirements when you are undertaking an assessment, because that is at the heart of this. If you get good assessments, good quality assessments undertaken by good quality experts, you will have a good result. And that's not rocket science. I mean, for example, in America, it's interesting because in the US, a parent can elect their own experts. They can say, we want the state to pay for an educational psychology report, and they can say the educational psychologist should perform this particular assessment. You can't perform the assessment of what you consider is appropriate, because the parent might be saying, well, actually, back in 2021, my child was assessed using a WISC assessment. I want the WISC assessment to be performed again because I want to see whether there's been any progress. What we're often seeing is that a local authority assessment might be conducted using a particular kind of assessment tool, and then in a year or two from now, they do an entirely different assessment. So you can't compare them. And it's very difficult for parents to say, well, actually, has my child made any progress? So I think in America, you can force the state to require the particular expert to do a particular kind of assessment. And I think those kind of things will really improve the system. It will also add to transparency. It will encourage parents to think that there's something meaningful that's going to come out of the process. Because the other thing that you mentioned, I agree that there's very, very good statistics that demonstrate that parents seem to be winning in the tribunal system, but really, is it a win? I mean, let's just imagine that a parent might go to the tribunal believing that they are winning, but what they've actually won is something that a proper assessment might have revealed should have been something else. Some other provisions should have been put into place. So I think the headline point for me is assessments.
Absolutely, Mike. I couldn't agree more. Couldn't agree more. It's rare, as you say, that the tribunal would intervene and order that there be assessments. It actually did occur to me, however, during a case management hearing on a particular case with a family and a client who themselves were disabled, and it was something that the court did at the case management hearing. It was discussed, and the local authority were then directed to seek out assessments from particular individuals, which at the time were speech and language, occupational therapy, educational psychology. And the tribunal also went further to direct that the specification and quantification must be an essential part of those assessments. And as you say, as soon as you have, and this is the thing I tell my clients a lot, Mike, and I know you have as well, because it's the trick I learned from you, is that, of course, it's not our role to recommend what a child needs. We're not clinicians. It's not for us to say that a child needs a specialist school or needs a one-to-one in a mainstream school or what have you. That's not our role. Our role is to gather and follow the evidence of clinicians who are trained and expert in making those recommendations. And often these cases, as you rightly explained, are impeded because those assessments either don't exist or they are inadequate. And as you say, quality assessments are going to give all parties the roadmap to getting this right and making a quality report. It's a phrase used, I know, in software design of all things, where they say, garbage in, garbage out. If you have bad data going into any process, doesn't matter how good the process is, you're going to get a bad outcome. And that's, I think, what you and I are both saying here, is that at the heart of these issues, at the heart of this non-compliance, is a fundamental failure to properly assess and understand the children's needs or the young person's needs, and just following that evidence. It is very much a glaring hole that, in many ways, all of these changes, as we've discussed, as you rightly point out, Mike, all these bells and whistles as they might be, and even the elements that we find concerning, at the end of the day, they will all be for naught if at the heart of this, we don't understand the child's needs. And really, that's the key reform that they need to make.
Well, Chris, I agree. I mean, as I said in my post back in June, two things really, and that epitomizes where I am in regard to the SEND proposals, is that the first point is quality assessments. We really need to be focusing on that. And the second thing is transparency and proper good information sharing. I think if there's more transparency, there'd be far more likelihood that the parents and children working in that system will have a greater level of trust in the system. And that will result in fewer disputed cases. That will result to many more children's needs being met, and an approach that encourages a genuine partnership is far more likely to succeed.
Absolutely, Mike. Thank you for that. Well, I think that brings us to a nice close there of our summary of the SEND reforms. Just to make you all aware, the consultation responses have all been submitted before the end of July, and the government will now be considering those consultation responses as part of its review. A consultation report will follow. We don't yet have a deadline, but hopefully soon. And Mike, will you come back to us and have another one of these episodes once the consultation process has been complete and the next stage of the report is out?
Absolutely, Chris. I mean, at the moment, as I say, we've got a system, lots of objectives, and we're looking at them, but there's not a lot of detail, not enough detail. So I will come and give a more critical analysis when I see that detail. But thanks to all our viewers. Thank you so much for joining us today.
And thank you, Mike. And thanks to you all for watching. We will see you on the next episode of the Education Magazine.